All right, let's proceed.
All rise. Good morning. Thursday's District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. All courts in session, there'll be no meetings, speaking, talking, double chewing, or arms resting on benches. If you have a phone, put it on silent. Thank you.
This is case number 24-153-426. This is LBNB funding versus LaQuisha Mitchell. The matter is before the court set on for a pretrial conference. The court is also in receipt and the court is in receipt of it and has set a hearing on a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good judge, may it please the court. I'm attorney Richard Grusin. My bar number is 35222. I'm the attorney for plaintiff. I'm also the moving party for plaintiff's motion for judgment.
Just one moment, counsel.
What's wrong, Judge?
I call it first. That's all right. I believe I called a different case number, so the number on this case is 2415891, and indeed it is LBNB funding versus LaQuisha Mitchell. Thank you for your appearance, counsel. Do I have LaQuisha Mitchell present?
Yes, sir.
All right. Good morning to you, Ms. Mitchell. Ms. Mitchell is present in the courtroom at this time, right? And I set this matter for hearing regarding the motion for summary disposition in this matter, and I don't believe that I received a written response to that motion from you, Ms. Mitchell. Is that correct? You filed a writing regarding the motion, true?
I did when I first came. I was supposed to do it a second time.
So you filed an answer to the complaint, right? Correct. But you didn't file any response to the motion, correct?
I wasn't.
That's a yes or no question?
No.
Not a trick question. Just want to make sure that there was not something that you filed and I don't have it here. That's why I'm asking. Okay, got it. All right, Mr. Rosen, you may proceed then at this time on the motion. And I don't know if the parties had a chance to talk or anything like that, but go right ahead, sir.
Well, thank you, Judge. Working in a crab-like motion, no, the parties have not had an opportunity to talk other than what occurred at the previous pretrial conference in this matter. As a result of that pretrial conference of February 10th, the court granted discovery. I sent written discovery to defendant on or about February 12th, 2025, consisting of requests for admissions, interrogatories, and a production of document. The production of document is a very short one line matter, which asks the defendant to produce all documents that the defendant would rely upon to demonstrate her meritorious defenses at the time of trial. I received no answer to that written discovery. Therefore, Judge, I filed this pending motion for summary disposition, and I filed that on or about March 17th. Again, notice to defendant. I have had no written response to my motion for summary judgment, which is absolutely required under MCR 2.116 G1. That core rule mandates that a respondent must file a written response to petitioner's motions for summary disposition at least 7 days before the day of the hearing. Today is the date of the hearing on April 15th, 2025. I would ask that judgment be entered in the amount of the complaint. Let the complaint being filed in the amount of $2,167.42. That's 2167.42. I ask also for taxable costs pursuant to Michigan 2.625 in the amount of a $75 summons filing fee, a $106.92 summons service fee $40 in motion fees, a total cost request in the amount of $221.92. That's 221.92. I also asked for a $20 statutory attorney fee concurrent with this motion. A total judgment I pray for, Your Honor, today is in the amount of $2,409.34. That's 2409.34. With this, I rest.
All right, so ma'am, the motion that has been filed is a motion that says that you have failed to raise a factual dispute or legal dispute to the claim. And of course, you didn't file a response to the motion, but I mean, the general nature of this is that this is a credit card that an obligation to pay it wasn't paid, and the lawsuit came and you responded to it. But I have to look to see whether or not there was a legal or factual defense to the claim that's been asserted. And that's what the motion is about. The motion is saying that there is not. And moreover, with the motion, counsel has argued that he sent out some discovery and that those items were not responded to. If they're not responded to within the time by law, they become admitted in terms of admitted against your interests. So tell me what you want to tell me today.
I just received this a couple of days ago. It's marked on March 17th. And the motion is saying to contact them directly. So I knew I was coming here, so I didn't figure why would I contact them directly if I was working.
Yeah, well, there are a lot of things that interplay with that. Sometimes you contact the other side when you want to discuss ways to try to get it resolved. So that there's nothing wrong with that. The court date is significantly important. So the right thing is for you to either be here in person or on Zoom. So you're here. The challenge is what defense do you have to the claim of indebtedness?
They sent me some paperwork dated on here February 12th. Everything on here is redacted. There's no signature that I presented. There's no copy of me sending in the ID. Because anytime I've gotten a loan from my bank or from my retirement plan, I always had to fill out some paperwork, send in my picture of my signature as well as my ID. Everything on here is redacted. I don't even know what I'm even reading.
Mr. Rosen, were you able to hear those statements?
Well, I had a little difficulty hearing defendant, Your Honor, in the courtroom. I did glean enough. I'm reviewing this complaint, even as we speak. It was a 2-page answer, and as I reviewed it, like the court indicates, the challenge is that Ms. Mitchell indicates her answer, I don't know, I don't know, I don't know, I don't know. So therefore, that's why when the court granted written discovery, I sent written discovery with all the documentation forming the basis of my client's claim. My client is a assigned debt buyer, where I attach over 14 pages of a loan that the plaintiff's assignee web bank shows that they had with Ms. Mitchell that was open on or about October 4th of 2021. There were payments made, and then there was a suspension of payments after April 21 of 2022. After no further payments after 6 months, WebBank, under FDIC rules, closed the loan, charged it off for non-payment, and then it was assigned to LBNV Funny as well as the first assignment. And that is what we have today. I appreciate what defendant says, but she's produced nothing in this record that would show otherwise, that defendant's defenses are not meritorious, that there is no offset or credit to the $2,167.42 balance that the web bank had with a defaulted loan with Ms. Mitchell. And that is the sum and substance of my argument, Judge. And with that, I rest.
All right, thank you, counsel. Now, anything else you wanted to say at this time?
I mean, I still don't see where the proof is. Where's my ID? Where's my actual signature? I mean, in the world of identity theft, this could be anybody. I mean, but everything on here says redacted. So I don't even know what I'm looking for.
All right, thank you now. I've listened to the arguments on the motion for summary disposition, and the court has to look to the pleadings and to any responses in relationship to discovery to make a determination as to whether or not the plaintiff has stated a valid claim before the court. And then secondly, whether or not there is a genuine issue of material fact, whether or not there is a genuine dispute. The fact that there is not, if you will, in this case, offered a wet signature, the fact that there is not some photographic information does not prevent the advancement of the claim that is brought in this matter. The defense to the claim is a denial that of any knowledge regarding this claim. That is insufficient, particularly where there has not been, even in response to the motion, something in the nature of an affidavit denying the claim, which is one of the things that could be used as a way of trying to challenge the motion in this matter. There is no genuine issue of material fact, therefore, and there is no genuine dispute in this matter. The indebtedness is made clear by the presentation of the complaint, and when the court looks to the answer to the complaint, the answer does not sufficiently rebut the claims that are raised in the complaint. And then moreover, upon the court allowing discovery and upon the filing of the motion, there has not been the presentation of any type of validation, such as a affidavit or anything along those lines that might serve to rebut the claim in this matter. For that reason, the plaintiff has met the burden that is required for the motion for summary disposition, and on that basis, the motion will be granted because there is not a valid defense in this matter, and there's no genuine issue of material fact. Plaintiff is entitled to judgment as a matter of law, and I will grant that judgment on the granting of the motion for summary disposition. That's my determination in this matter, and I will sign orders consistent with the same. I wish you well, man. Thank you, counsel. Good day to both sides.
Thank you, Judge. I rest.
Mr. Ruser, you're going to need to present a judgment on this. We did present an order regarding this motion for summary disposition. I am signing that order in regard to the judgment itself. You'll need to submit the judgment, sir. All right, guys, thank you. This is case number 24-169-245. This is J.P. Morgan Chase Bank versus Romel Jackson. The matter is before the court, set on for a status conference, first hearing regarding this matter. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. It's Craig Fay, P8140 on behalf of plaintiff.
Thank you, Mr. Fay. Good morning to you. I'm looking for counsel for Mr. Jackson. If you're on the Zoom, please say something at this time. Do I have Romel Jackson? I'm looking for counsel for Romel Jackson. If you're on the Zoom, please say something. Mel Jackson. All right, counsel, Mr. Fay, any information in this regard? I do see that there looks like there's an attorney whose office is stationed in Las Vegas who has entered an appearance regarding this matter for the defendant. Any information that you have, sir?
Yeah, so it looks like we do have it resolved pending just the return of a signed consent judgment. So if the court would maybe just adjourn this out, I'm going to send an email to opposing counsel right after the hearing, send them a copy of the consent judgment. We can hopefully get that filed within a couple of days.
All right. I will note the same items for the record here. I will, I'm gonna go ahead and set it over for, just one moment, I'm looking at dates now. I'm gonna set it over for the 13th of May, and that's just to give some time for the documents to get in. In the event there's a problem, then I have it set for May 13th at 9:45 a.m. May 13th, 9:45 a.m. for review.
Perfect, that works.
All right, this is case number 24163450. This is Discover Bank versus Nadia Mosley. The matter is before the court on the following of the motion for summary disposition. Your appearance for the plaintiff, Discover Bank, please.
Yes, sir. Your Honor, Michael Spoolman, P41216, of counsel for Buckles and Buckles today for Discover Bank for this motion.
All right, thank you, Mr. Coleman. I'm looking now for Nadia Mosley. If you are on this Zoom or any counsel for Ms. Mosley, say something at this time. All right, I'm looking, I did receive a motion to reschedule. Let's see when that was. And I signed an order on 3/13. But there is nothing changed about today's hearing date. This is the date for hearing on this matter. Again, I'm looking for Nadia Mosley or anybody connected to Mosley. All right, counsel, any information you have in this regard, sir?
I do not have any information regarding her non-appearance today, Your Honor.
So what happened at the last hearing, as I understand it, it looks like the defendant had demanded arbitration pursuant to the contract. And I issued an order on the 13th of March that petitioner has to follow the requirements and steps that are contained in a contractual agreement between the parties. She indicated in her petition that was filed on March 10th that I have not received correspondence from Discover Bank regarding the coverage of fees for arbitration. I cannot file arbitration without a response. I directed her to follow whatever the agreement is. Looks like she's not here today, counsel. Your position at this time, sir?
Your Honor, thank you. First of all, number one, as indicated, I don't know why she is not here or would fail to appear. Number two, per the court's previously cited order, the court looked like it was trying to give her a chance to pursue that avenue if she was, in fact, interested actually in doing that. I guess the part of the premise would be that, in our argument, would be that if she was serious about having done so, she would have, it would be incumbent upon her to show some type of filing of a letter to Discover Bank or the plaintiff's attorneys requesting arbitration and or assistance with fees, etc. If that was what she was seeking to do. To my knowledge, nothing of that sort has been filed to show the court she was pursuing that avenue. I did specifically inquire of Buckles if they had anything in those regards, and they said no, they didn't. Regardless of that, Judge, I would further indicate that plaintiff, in its motion for summary disposition, did address the issue of arbitration, pages 16 through 19 of their brief. That it's not in accordance with the statute governing arbitration, Michigan Uniform Arbitration Act, and not timely. And further also indicate, Judge, no response has been filed to my knowledge with the court and none received by plaintiff's attorneys in response to the motion, and certainly nothing within the time required, I would think. So for all those things, Judge, we don't feel that there is a valid defense here or a factual issue such that the court would actually need a trial in order to be able to resolve the matter, we would respectfully ask that the motion be granted at this time for the total amount requested, which inclusive of costs is $2,911.76. Plaintiff would respectfully move for entry of a judgment for same at this time.
All right, the court, on the defendant's request for arbitration, adjourned the matter and allowed the defendant to pursue that avenue. He has set this date up as a subsequent date for hearing on the motion for summary disposition as well as pretrial. The defendant has not appeared and has not responded to the motion in this matter. Accordingly, the motion for summary disposition will be granted at this time, finding that there is no genuine issue of material fact, and the defendant has failed to plead a valid defense regarding this matter. Judgment may enter on the granting of the motion for summary disposition, which is granted at this time.
Thank you, Judge. Normally, Buckles' procedure is to submit a judgment, proposed judgment with the motion. My inquiry would be, Judge, if the court actually has one there to sign at this time, or if the court would like us to submit one under the 7-day or otherwise.
I am in receipt of the proposed order. I reviewed that proposed order. It is consistent with the complaint as pled in this matter and with costs associated herewith. The court signing the judgment based upon the granting of the motion for summary disposition. Thank you, Counsel.
Thank you, Your Honor. Maybe I be excused.
Yes, sir. Also.
Thank you, sir. Have a good day.
The court now calls case number 24-17-1000. This is Aspen Creek Apartments Limited versus Jawan Reed. The matter is before the status conference. Your appearance for Aspen.
Morning, Your Honor. Robert Visconti, P61756 on behalf of the plaintiff.
All right, thank you, Mr. Visconti, and good morning to you. I'm looking for Ms. Reed now, Jawan Reed, I should say. Sorry, Jawan Reed. Say something if you're there. Jawan Reed. If you are Jawan Reed, I need you to say something at this time. Good morning. All right, it looks like that person has not appeared. I did receive a handwritten letter that says, I, Jawan Reed, feel as I don't owe Aspen Creek Apartments the amount of money they are asking for because of various reasons. That is the full extent of the note that I received dated or filed on February the 11th of 2025. The court treated it as an answer for purposes of setting this hearing and to give the defendant opportunity to come in and maybe tell me what they talked about by way of their defense. So once again, do I have Jawan Reed on the Zoom anywhere? All right, it appears that the defendant has not appeared. The record should reflect that the court did send a notice to the address on Fordham Street, indicating to the defendant that today was the date set for hearing this matter. That notice was sent out on February the 18th of 2025. Counsel, your pleasure at this time.
Your Honor, based upon defendant's failure to appear, I would move the court at this point for entry of a default judgment. We have a balance due pursuant to the lease agreement of $4,944. I believe that's the amount that was pled in the complaint. We also have taxable costs to the defendant of $243.54 for a grand total of $5,187.54. And I'd be happy to submit a judgment to the court for entry in that amount.
All right, given that the defendant has not appeared as directed to do so, and given that the defendant's answer as filed does not plead a defense to the claim in this matter, the court will find, number one, that the defendant is in default, and that the plaintiff may move forward with judgment based upon the default that is now entered. Thank you, counsel.
Thank you, Your Honor. We'll submit the order. Have a good day.
The court calls case number 24171457. This is Rodney Chiropractic versus Auto Club Insurance Association. The matter is before the court. Looks like it's set on for a status conference.
Good morning, Your Honor. Mike Fortin is here on behalf of plaintiff P46541.
Good morning, Honor. Margaret Fitzgerald on behalf of defendant P80966.
All right, good morning to both of you. Where are things in regard to this matter? Update me, if you will.
Yes,
I'll
Your
let
Honor.
counsel speak, Your Honor.
Thanks, Mr. Fortner. This is our first pre-trial. I would ask that discovery is open. We're just defendant would just ask for 60 days discovery, and we should be able to wrap this up. The applicable policy is a $50,000 allowable expense. I'm waiting for confirmation that no other provider suits have been filed as it relates to this claim, and hopefully we'll be able to settle it.
Counsel, did you say 15,000 or 50,000?
50,000, 50,000.
All right. So I'll go ahead and set up a 60-day discovery order with a return date of 24th.
You said 24th of June?
Can I do it the 19th of June?
See, no, we're closed.
Okay, so the 24th.
You said the 24th? Yes.
6/24/25, 9:30 will be the return date. Discovery will be open through that date. I will issue a scheduling order today. It will be sent via mail. But again, the return date is 6/24/25 at 9:30. That date will be contained within the document, and discovery is open through that date as well.
All right, thank you.
Thank
Your
you.
Honor.
All right.
Thank you.
Good day.
You too. Thank you.
This is case number 24240607. This is Khalil Lagan versus Goach and Sons Towing Incorporated. The matter is before the court, set on for a pretrial conference. Your appearance for Goach and Sons Towing, please.
James Austin on behalf of Gosh and Sons Towing, Your Honor.
All right, thank you. Your P number, if you will, for the record.
P43400.
All right, any other counsel? I saw improper, but it looks like there may be another counsel.
Mr. Walker is here.
I'm sorry. Mr. Walker, I'm sorry, sir. Your appearance, sir.
Lawrence Walker on behalf of the plaintiff, P36091.
All right, thank you. Good morning to both of you. All right, so somebody update me. Where are things? I know I allowed some discovery, and we set this over as a pretrial conference date. So go ahead and update me, Mr. Walker, if you will.
Well, we sent out discovery to the defendants, and that discovery is due. I did send out an email to counsel with respect to his outstanding discovery. I received an email back, and I guess he's trying to get some documents from his client. I don't have a problem stipulating to an order that the discovery will be provided within a certain number of days. There's not a whole lot of discovery that needs to be taken.
I have no problem with that either, Your Honor.
All right, so why don't we why don't we see if we can close it out by the 29th of April? So that gives you 14 days from today's date, to close those items out. And then I'm looking to set a subsequent date, of hearing regarding this matter, in the month of May. The parties have a time to kind of go over discovery and then figure out if there is a way to get this resolved. So I'm looking at the 27th of May as a return date.
Your Honor, I think I will be out of the country. I return June the 2nd.
All right, so the other thing we could do is a little earlier, or obviously move it forward. So I would be thinking either the 22nd of May, I could squeeze it in there, or we could move it until the 5th of June. Mr. Walker, when did you say you'd be back? So
I'll be back June the 2nd. The
that would be 5th of June.
5th of June works fine.
So June 5, at 9:30 be the next action date of this matter. And I'm ordering that outstanding discovery items be perfected by the 29th of April. I'll review the matter on the 5th of June.
That's fine. And council and I will be in touch. Maybe we can bring this to a head before any of those dates.
We will see what we can do. Your Honor, I do have a conflicting hearing in Oceana County on the 5th, but I will see if I can get that taken care of as well.
All right, sounds good. And just let us know. I mean, we can always, on relatively short notice, get both of the attorneys in, and I'll take out whatever time is needed to try and.
I will keep in touch with Mr. Walker and hopefully he'll be very jet lagged on the 5th and he'll need a little more time.
Good day to both of you, and I do see that Ms. Lagan is on as well. Good day to you as well, ma'am.
Thank you, Your Honor.
All right, good day. The court now calls case number 24-1223. This is Christopher Kendall versus Peter Carter. The matter is before the court on the issuance of a subpoena. Do I have Christopher Kendall on this phone?
Yes.
All right, good morning to you, Mr. Kendall. I'm looking for Peter Carter at this time. Mr. Carter, if you're on this Zoom, please say something. Peter Carter. All right, Mr. Kendall, were you able to get the subpoena served, sir?
Yes. Yes, I was. And then I took it back to the courthouse last week. I had my folder in front of me, but now I can't seem to find it, but I should find it in a second or so.
Not a problem. All right, I don't see the proof document contained in the court's file. It doesn't mean that it hasn't been presented. It just hasn't populated into the file. And let me do one thing. Just one moment. So can you run me ROA on this one? Not a part, that's 24, 1223.
Okay.
All
I
right.
have the paperwork.
And I told you that I would allow you to proceed at this time. It looks like Mr. Carter did not appear. Have you had any contact with Mr. Carter? Any phone calls or any efforts to reach out on this matter, talk to me?
No.
All right, given that the defendant has not appeared for the, excuse me, for the subpoena on today's date, the court will issue an order to show cause, and the defendant must appear to show cause why it should not be held in contempt of court, or why a bench warrant should not issue. So I'm going to set a show cause that you will need to fill out the show cause form, and to have that form served on Mr. Carter. If he doesn't appear for the show cause, then a bench warrant will issue, which will allow for the sheriff's department to arrest him. And I'll set bond on that bench warrant. But you got to issue the order, the petition to show cause for. So the date of hearing that I'm going to set for that, just one moment here, sir. Will be the 27th of May, 5/27.
Can you do 28?
I'm looking to see, is there a space in which I can do it earlier than that?
In May? Oh, you can do it May 21st?
Oh, the 21st? All right, May 21st. May 21st is going to be the hearing day there. And that's going to be at 9:30 a.m. 5/21 and 9:30. So you need to get the petition to show cause form filled out right away, so that I can sign off on the order. And then you have that served. And then on May 21st, if the defendant shows up, we'll address the appropriate issues. If he doesn't show up, then a bench warrant will issue, and you'll take that to the sheriff's department. And go from there. So 5/21 at 9:30 is your return date. Make sure you get the paperwork to the ASAP.
And so I bring the petition to show cause to the courthouse, and then they'll bring it to you, they'll give it to you, and then from that point I show up on May 21st.
Absolutely. Yeah. And so once I sign it, we're gonna get that right to you, and once you get it, you send it to the defendant, make sure that he gets it.
Got it. So I'll receive the form back in the mail, and then I'll mail that to the defendant.
Yes, and if you come down to the court with the and fill out the forms, whatever, you could bring it up to the court. My courtroom is 534, and you could likely get that signed back in your hands. So you can
Okay.
All right. So all the best. I'll see you. I'll see you on the 21st.
Thank you, Your Honor.
Thank you. All right, court calls case number 24-240-608 and 609. This is Gabrielle Coleman versus AB Cut Rate Repair LLC. Your appearance, the appearance of any counsel in regard to this matter.
Good morning, Your Honor. Ziad Cassett, P72237 for the defendant.
All right, thank you, Mr. Cassett. Good morning to you. Gabrielle Coleman, or any attorney from Ms. Coleman, anyone on this case, say something at this time.
Good morning, Your Honor. This is Gabrielle Colvin.
All right, thank you, Ms. Coleman, and good morning to you, ma'am.
Yes.
So I do have the matter set for a final pretrial conference. Let me ask you, counsel, has the parties had any meaningful discussion regarding possible resolution of these combined matters?
Judge, the parties attended, mediation, I would say probably about 2 to 3 weeks ago. I don't have the exact date in front of me. The parties were they attempted to resolve it, were not able to resolve it. So now we're back before you, and I think we just need a trial date, and possibly there were some facts that came out at the mediation, which I may want to file a dispositive motion unless the court wants to hold a final settlement conference. I don't know how the court handles these things, but.
Yeah, well, I did, just so that both of you know, I did receive a notation from mediation, and thank you for referencing the same. And it simply told me that the parties did appear and participated, but were not able to resolve the matter. It did not get into any details. It's just a mediation status report that simply said the parties were not able to resolve. All right, so let me look at one other thing here. I see that the claim in this matter is in the nature of $7,000. I mean, I'd be glad to, well, let's do it this way. I'm going to go ahead and set the matter on for trial. And I will take some time on the date of trial to see if there's some room for the parties to come together. I mean, I don't mind doing it before that, but I want it to be meaningful. And obviously, we've already been through a mediated process, and it seems that the parties went there in good faith. It doesn't seem like there was just a perfunctory thing. So I have to take that into consideration and how we go forward. Go ahead, counsel. You had something you want to say? Sir?
Yeah, Judge, if I may, and if the court would oblige, if the court is going to or is willing to conduct a settlement conference with the parties, I would prefer that it's done on a date separate from trial. I'd hate to charge my client to prep for trial, and even, prepare some type of dispositive motion if this thing can be resolved. If the court would allow, that would much be my preference. And if we can't settle it on that day, maybe issue a trial date on that day.
All right, let me get the thinking of this caller now. Anything you wanted to say in this regard?
Yes, Your Honor. Thank you for allowing me to speak. During the mediation, our mediator, Ms. Sweeney, had some requirements for us. And one was to allow each other to speak and while during the mediation, and that Attorney Casey did not speak at all. Neither of those things happened. Also, Attorney Casey must not have gotten a notation that Jayante Baker was entered as a witness. They would not allow him to speak. They said Attorney Casey said he wasn't part of the case, and he very much was. We entered his name on February 7th, along with some discovery evidence, which was a video of him trying to start the car over and over again. And Jayante didn't get an opportunity to speak because Attorney Casey said he was not a part of it. And I have the notation right here, the day that we faxed it over, when we were asked to be sure any other parties were going to be a part of this to enter it at that time, unless I misunderstood that. So
Let me stop you there for just a moment. The fact of the matter is that obviously mediation didn't work, and some of it may not at work because of some things that were not understood. Typically, mediation efforts, only the parties, not persons that may be witnesses, only the parties are really involved in that engagement. So it would have only been yourself and the defendant that would have been involved in this, and trying to mediate that. So for whatever reason, it did not work out as well as it perhaps maybe it could have. So we move on to the next stage. What I'll do, it sounds to me like both sides want to have a chance to kind of talk it out and see if there's a way to find common ground. So I'm going to go ahead and set a date for the parties to come here to the court, and I'll take some time to, without getting into great detail, because I may have to try the case, but I'll take some time to hear from both sides in a mediation type setting to try and see if there's a way to bring this case together. So I'm going to go ahead and set a date towards that end, and I'll allow the parties to tell me what they think the case is about in general and what they believe the case should resolve for. And then I'll make my recommendation to see if there's anything that can be done to bridge the gap. If not, then the next step would be for the court to set it up for a trial date, and the parties present their evidence, and the court ultimately make a decision based upon the outcome of the case. You know, I think somewhere in the neighborhood of 90% of cases are resolved by way of settlement, by way of parties coming together and reaching an agreement. So it's at least worth talking about it to see if that can happen. But if it can't happen, then the court will make a decision after hearing the evidence at trial. So let me go ahead and get you set up for, can I do this, can I do that type of event on the 30th of April?
April 30th. You have a trial.
I'm thinking about it like 11 o'clock. I have a trial on that day.
You can do it on May the 2nd.
All right, May 2nd. May 2nd at 10:30. All right, so you'll report to the court. My courtroom is 534. We're going to send a notice out to you, and I will take some time in person to address the issues that may be here, to see if the parties have room to come together to try to resolve this. So that's going to be May 2nd, 2025 at 10:30 a.m.
Did you say 10:30, Your Honor?
Yes. Yes, ma'am.
Okay, thank you.
Thank you. You'll get a notice in the mail in that regard as well.
Thank you, Judge. I appreciate you taking the time to do that.
All right, thank you. And good day to both of you. I'll see you on that day.
All right, bye-bye.
Okay. Enjoy the rest of your day.
Likewise. Now, let's set a settlement conference.
Okay.
All right, this is 24-15326. This is Citibank versus Rashida Taylor. Matters before the court set off on a motion for summary disposition. I adjourned the motion hearing at the last event. It appears that the parties have made some traction towards resolving it, and I think one defendant counsel was not present at that time.
I'm present, Your Honor.
At that time, at the previous hearing.
Oh, at that time.
Your appearance for plaintiff, please.
Again, good morning, Your Honor. It's Craig Fay, P81401 on behalf of plaintiff.
All right, thank you. For defendant, you may at this time, sir.
Good morning, Your Honor. Matthew Langston, P7983, appearing on behalf of the defendant.
All right, thank you. Thank you, Mr. Langston. Good morning and good to see you. This was the first case that I called, and somehow the paperwork, another file was the file, and this was the case number. So something got mixed up, and then somehow this one ended up at the bottom. So I apologize. I apologize. It was on top, but it ended up at the bottom, so I messed up. All right, so, tell me what's going on here, update me if you will.
Sure. So we did have actually this morning, we were sending back and forth a couple proposals. We're relatively close. I don't know if the court would want to entertain maybe a short adjournment, but I think we should be able to get it resolved. We're actually, I guess, in a sense, pretty close.
$220 apart, Your Honor.
Yes.
So I think we're extremely close.
Yes.
It's just an offer that plaintiff's counsel has presented that I need to go back to see if that's something my client would approve. But we are extremely close.
I got it. Yeah, that's, Mr. Fay said pretty close hesitantly a couple of times, and so I'm thinking, what? Sounds like they're thousands apart. But in any event, sometimes closer you are, the further you are away, but that's another story for another time. So I'll have a look at it in, what do you want to do, a couple of weeks or 30 days? What do you think, Mr. Lyson?
30 days would probably be completely fine. That's what plaintiff's counsel and I had discussed earlier this morning, I believe.
Yeah, we do have Your Honor, because I had another one earlier today that was adjourned to May 13th. That date that would work, if that's okay with the court.
Very good. So we'll go ahead and set it over for the 13th of May, and that's going to be at 9:45 p.m.
Perfect.
Your Honor, May 13th, I do want to correct myself. I said 30 days as what we had discussed. We'd actually discussed 90 days, but 30 days works completely fine with me. I didn't want to misrepresent what counsel and I had discussed.
Thank you. All right, very well. So I'll look to see you on 5/13/25 at 9:45. Good day, gentlemen.
Perfect. Thank you. And have a good day, everyone.
You too.